I know Larry wants to address the court as well.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
Thank you. You need to come up right up to the podium, right to the microphone. What would you like me to know?
It's just a short statement. Your words these past several days, your words, have had a significant emotional effect on myself and has shaken me to my core. I also recognize that what I am feeling pales in comparison to the pain, trauma, and emotional destruction that all of you are feeling. There are no words that can describe the depth and breadth of how sorry I am for what has occurred. An acceptable apology.
Sir, you need to stay at the microphone or they can't hear you.
An acceptable apology to all of you is impossible to write and convey. I will carry your words with me for the rest of my days.
Sir, I hope that's true. I hope you are shaken to your core. Your victims are clearly shaken to their core. And I know there are still some who ask, are you broken because you got caught? First, let me address counsel. I agree with your words in regard to no one should blame defense counsel, and vigilante crime is not tolerated. So I hope that no one will do anything untoward against counsel, their children, their families, their firms, their cars, whatever it is. That is crime. Crime plus crime solves absolutely nothing. Please respect their job. It's a difficult one. I know I've been in their shoes, and the Sixth Amendment does guarantee each defendant the right to counsel. Doesn't matter what the defendant has done, but they have the right to counsel. I also want to say, that being said, we also have the First Amendment. So you are all free to have your own opinions. And it's always a balancing act between the First Amendment, the Sixth Amendment, all of the due process and other amendments to the Constitution. They are all valuable in their own way. And that's why we have an organized and just society, and that's why we are here today, because this defendant has been brought to justice. Do not make it worse, please. Before I get to sentencing, I want to talk about a couple of things. And first, I've said what I need to say to the victims. I have a little bit more to say. You are no longer victims. You are survivors. You're very strong, and I've addressed you individually. Before I say anything further, I don't know if you all know this, and I know that the world is watching. I know this because I'm on the bench every day, and this isn't the only heinous crime that appears in this court. The National Crime Victimization Survey that's done by the Justice Department annually reports that 310 out of every 1,000 assaults are reported to police, which means that 2 out of 3 go unreported. The voices of the survivors have asked everyone, report, keep your voice up. Rachel's voice hopefully will raise these numbers of reports and all of your voices. But that statistic does not include children 12 and under. 1 in 10 children will be sexually abused by their 18th birthday. 1 in 7 girls, 1 in 25 boys by their 18th birthday. That means that in the United States, I'm not talking about any other country, But in the United States, 400,000 babies born in the U.S. will become victims of child sexual abuse. It stops now. Speak out like these survivors. Become part of the army. I do one case at a time. And I really so very much appreciate all of your thank yous. I read some of the Twitters and Facebooks and all of what's going on in the media. I'm not special. I'm doing my job. If you come into my courtroom any Wednesday and watch sentencing, I give everybody a voice. I give defendants a voice, their families when they're here. I give victims a voice. I try to treat everybody like family because that's the justice system that I was raised to believe in. I came to this country stateless. I'm naturalized. My father's Maltese, my mother's German, and I was raised on old country values. And my grandmother always told me, and my parents always told me, my grandfather too, that America is the greatest country. I believe that. That's why I served in the military. That's why I've always done community service. I'm not really well liked because I speak out. I don't have many friends because I speak out. If you ask me a question, you better be ready for the answer. I speak out because I want change, because I don't believe in hiding the truth, and I'm not saying I'm always right, but I try. I also don't believe that one size fits all when it comes to sentencing. Another reason I listen. I know that there are some judges for every crime that give the same punishment. I don't think that's justice. I believe in individualized sentencing. I follow the Constitution, and I believe our system works. I also believe these survivors. Now, there's case law about how I can consider what I can consider. And first and foremost, my sentence reflects the 7 in regard to who defendant pled to. But the remainder of you, the 161 others, add to the credibility of those 7. So technically, I'm considering everything, everyone, because your crime, all of your crimes, the depth of them have cut into the core of this community and many communities and all of the families and people we don't even know. And sir, the media has asked me to release your letter. I'm not going to do that. Counsel may object, the media may object, but there is some information in here that troubles me in regard to the victims. And I don't want them re-victimized by the words that you have in here. But I do want to read some more of your letter. And the reason I want to do that is because I've considered it in sentencing as an extension of your apology and whether I believe it or not. So I want you to hear your words. I've already read some, and I'm not reading every line. Well, let me begin. The federal judge went ballistic at sentencing since I pled guilty to the state cases and spent 10% on the federal case and 90% on the state cases and civil suits. She gave me 60 years instead of 5 to 20 years, in parentheses, 3 consecutive 20-year sentences. I pleaded guilty to possession of porn from 9/2004 to 12/2004, 4 months. The prosecutor even admitted that I never belonged to any porn sites, any chat rooms, was not on the dark web, and also they could not prove I viewed it. It was all deleted, of course. I shared my electronics, and I could not prove that. So for 4 months of porn possession from 2004, I was sentenced to 60 years. Not proper, appropriate, fair. Going down a few lines. What I did in the state cases was medical, not sexual. But because of the porn, I lost all support, thus another reason for the state guilty plea. Let me move down further. So I tried to avoid a trial to save the stress to this community, my family, the victims. Yet look what is happening. It is wrong. Let me move down further. I was a good doctor because my treatments worked, and those patients that are now speaking out were the same ones that praised and came back over and over and referred family and friends to see me. The media convinced them that everything I did was wrong and bad. They feel I broke their trust. Hell hath no fury like a woman scorned. It is just a complete nightmare. The stories that are being fabricated to sensationalize this, then they forced me to say that, or they were going to trial and not accepting the plea. I wanted to plead no contest, but the AG refused that. I was so manipulated by the AG and now Aquilina, and all I wanted was to minimize stress to everyone, like I wrote earlier. Going down a little bit further. In addition, with the federal case, my medical treatments with the Olympic/national team gymnastics were discussed as part of the plea. The FBI investigated them in 2015 and found nothing substantial because it was medical. Now they are seeking the media attention and financial reward. Would you like to withdraw your plea?
No, Your Honor.
Because you are guilty, aren't you? Are you guilty, sir?
I said my plea, exactly.
The new sign language has become treatment. These quotes, these air quotes, I will never see them again without thinking of you and your despicable acts. I don't care how they're used, I will always think of quotes and the word treatment. It was not treatment, what you did. It was not medical. There is no medical evidence that was ever brought. When this case first came to me, and I've told you this, and I apologize to the Olympians and athletes, but I have 5 children, 2 dogs. My parents live with me. I work 4 jobs. I don't have much time for television. I don't watch sports. Although last year I was a soccer coach, much to the laughter of my family. I didn't know anything about you, your name, or anything that was going on. And so when I kept saying, we're going to trial, here's the date, and everyone wanted more time, I said, no, here's the cutoff. And then the cases were merged and we delayed it. And I still thought, well, maybe there's a defense of medical treatment. And why did I think that? Because it's my job to be fair and impartial, but also because my 2 brothers and my father are very well known and respected doctors, real doctors with real treatments and research, dedicated to healing. I haven't considered that in this case, but I have heard from your survivors now that they trust doctors like I trust the doctors in my family and the doctors I go to. But I still thought, well, there's a defense of medical treatment, and there are changes in the medical community every day for the betterment. So up until the time you pled, I believed that maybe there was a defense here, despite the felony information. I was ready for trial. Your counsel was ready for trial. The Attorney General's office was ready for trial. You, sir, decided to plead because there was no medical treatment. You did this for your pleasure and your control. This letter, which comes 2 months after your plea, tells me that you have not yet owned what you did, that you still think that somehow you are right, that you are a doctor, that you're entitled, that you don't have to listen, and that you did treatment. I wouldn't send my dogs to you, sir. There's no treatment here. You finally told the truth. Inaction is an action. Silence is indifference. Justice requires action and a voice, and that is what has happened here in this court. 168 buckets of water were placed on your so-called match that got out of control. I also, like law enforcement, or like the Attorney General, want to thank law enforcement for their investigation, but I also want to be the voice on behalf of these survivors who asks law enforcement to continue their fine work and to also include the federal government. There has to be a massive investigation as to why there was inaction, why there was silence. Justice requires more than what I can do on this bench. I want to also applaud all of the counsel in the Attorney General's office. I want to also applaud defense counsel. You all have done fine work. You've made me proud of our legal system. We all work together for the betterment of our community, and that is law enforcement, prosecutors, defense counsel, investigators. There are countless people. It's the only way our system works. We need this balance. So all of you, when I look at myself as Lady Justice, my arms are like this. They are balanced. Prosecution, defense, they're balanced. It only starts to tip after there's a plea and after I take into consideration everything that's happened. So I want everyone to understand I've also done my homework. I always do. People versus Wacholowski. I'm sure I slaughtered the name. I apologize, but it is spelled Waclawski. 286 Mishath 634. It's a 2009 case. And in it, and I want you to clearly understand, it says, plainly, the law does not limit victims' impact statements to direct victims. It doesn't say, and I have found nowhere that limits me from having you hear all of your victims. As I said before, when counsel came to me and said, we're not going to go to trial, despite our court having already sent out 200 of the 800 juror requests. And they told me their plea, and would I consider it in lieu of trial? There was the agreement between us because I always, and they know it, they are familiar with me, let people speak. And I wanted all victims. And we had a discussion about which victims. And of course, there was an objection to one of them. I let it come in anyway. That was part of the plea that you entered into, to allow the victim impact statements. Because after that discussion, I know your lawyers, as good as they are, sat down with you and said, the judge is going to allow this. And when it comes down to it, I know it also because this was signed by the Attorney General, by defendant, and by defendant's counsel on November 22nd, 2017. Aside from the letter that you wrote a couple of months after your plea, which tells me you still don't get it, there's something I don't understand and I want to make clear. Sir, you knew you had a problem. That is clear to me. You knew you had a problem from a very young age, even before you were a doctor. You could have taken yourself away from temptation, and you did not. But worse yet, there isn't a survivor who hasn't come in here and said how world-renowned you were. I trust what they say. You could have gone anywhere in the world to be treated. You could have gone to any resort, any doctor place where you could get treatment. In Europe, they have all sorts of hidden places for things like this. No one had to know, and you could have found some treatment, some help, taken some medicine. You would have done that if you had cancer. I know you would have. You're about self-preservation. But you decided to not address what's inside you that causes this control urge, that causes you to be a sexual predator. So your urges escalated, and based on the numbers that we all know go unreported, I can't even guess how many vulnerable children and families you actually assaulted. Your decision to assault was precise, calculated, manipulative, devious, despicable. I don't have to add words because your survivors have said all of that, and I don't want to repeat it. You can't give them back their innocence, their youth. You can't give a father back his life, or one of your victims her life when she took it. You can't return the daughter to the mother, the father to the daughter. You played on everyone's vulnerability. I'm not vulnerable. Not to you, not to other criminals at that podium. I swore to uphold the Constitution and the law, and I am well trained. I know exactly what to do. And at this time, I'm going to do it. And I want you to know, as much as it was my honor and privilege to hear the sister survivors, it is my honor and privilege to sentence you. Because, sir, you do not deserve to walk outside of a prison ever again. You have done nothing to control those urges, and anywhere you walk, destruction will occur to those most vulnerable. Now, I am honoring the agreement. I'm also honoring what's been requested of me. And I want you to know I'm not good at math. I have a cheat sheet. I'm only a lawyer. I know that you have a lot of education in physics and math, but I have a cheat sheet. It is my privilege on counts 1, 2, 5, 8, 10, and 18. And 24. To sentence you to 40 years. And when I look at my cheat sheet, 40 years, just so you know and you can count it off your calendar, is 480 months. The tail end, because I need to send a message to the parole board in the event somehow God is gracious, and I know He is, and you survive the 60 years in federal court first, and then you start on my 40 years, you've gone off the page here as to what I'm doing. My page only goes to 100 years. Sir, I'm giving you 175 years, which is 2,100 months. I just signed your death warrant. I need everyone to be quiet. I still have contempt powers. I told you I'm not nice. I find that you don't get it, that you're a danger. You remain a danger. I'm a judge who believes in life and rehabilitation when rehabilitation is possible. I have many defendants come back here and show me the great things they've done in their lives after probation, after parole. I don't find that's possible with you. So, you will receive jail credit on counts 1, 2, 5, 8, 10, and 18 of 369 days. On count 24, you will have 370 days jail credit. If you are ever out, which is doubtful, you would be required to register with the Michigan Sex Offenders Registration Act, complying with all of the requirements of that act, in addition to global position monitoring system. You would wear a GPS. You will pay restitution in the amount to be determined based on whatever amounts are submitted, and your attorneys can ask me for a restitution hearing so that I can determine what a reasonable amount is for the victims. I am leaving restitution open as long as those victims have issues that can be medically documented. You will comply with DNA testing and pay a $60 fee for that. I suspect that was already done, but you owe $60 back to the county for that, or law enforcement, whoever will put it in the right pocket. You must submit to HIV testing and complete counseling associated with HIV and AIDS. You must waive confidentiality and allow test results and medical information obtained from this test to be released to the court. You will pay $476 in state costs. You will pay a crime victims assessment in the amount of $130. Does counsel wish to address court costs and fines? I don't know his financial state.
Judge, he doesn't have any money to pay in court costs and fines. If the court wants to impose it, the court can impose it.
I'm not imposing any court costs and fines, and here's the reason. I don't know what he has or what he'll get in the future. The victims deserve the money. The county will survive one way or another. I'm also going to make recommendations to the Michigan Department of Corrections for mental health treatment. I understand he has some medical conditions and he should be allowed to take medicine for that. We should have individual and group counseling, treatment for sexual predators, whatever they allow. I'm also going to send a message. I'm not sure, but I believe I read an article, sir, that you were treating people in prison that don't have a license. Don't commit any more crimes. I know you don't have any more lives to give, but you can't be treating people. You're not a doctor. So I'm not sure how that's happening. But I wanted to send that message. You have 21 days to appeal, 10 days to request court-appointed counsel. Do you acknowledge receipt of your appellate rights?
Your Honor, I've got the notice of right to appeal, and I'm providing it to my client now.
Do you acknowledge it?
Yes, Your Honor.
Thank you. Well, let me just say to the media, again, I'm just doing my job. I know you all want to talk to me. My secretary has informed me that I have a growing stack of requests from print media, from television, from magazines, from around the world, literally. This story is not about me. It never was about me. I hope I've opened some doors, but you see, I'm a little stupid because I thought everybody did what I did. And if they didn't, maybe they ought to, but I do this and have been doing it. And if you don't believe me, the keeper of my words is right by my side, and lawyers who are hearing this are shaking their heads saying, yep, I've waited too long as she lets everybody talk. Sometimes people get upset. I don't care, I get paid the same. So as to the media who want to talk with me, I'm not going to be making any statements. I know that my office, and I may have even, I don't know, been a couple of weeks, conveyed that after this is over, it's just not my story. After the appellate period runs, with victims by my side to tell their stories, I might answer some more questions than what I said on the record. I don't know what more I could possibly say. But I'm not going to talk with any media person until after the appeal period, and even then, if you talk to me about this case, I will have a survivor with me because it is their story. So I wanted everybody to hear that from me. I respect all of the media outlets. You've done just a fabulous job here. There hasn't been any commotion or upset by this, and I do believe in the First Amendment, so I thank you all for being here because it's an important story for the survivors. As to today, I know that there are a lot of survivors, family members, husbands, friends, a lot of people in the courtroom. You have voices. I'm going to leave the courtroom. Defendant will leave the courtroom. The attorneys may stay. Victims, family members, survivors, you may stay in the courtroom and talk with media. You can have your own press conference right here. Spur of the moment sometimes works out the best, doesn't it? Again, I won't make a statement until after the appeal period. And again, if there's any survivor then who, at that point, if somebody wants to talk to me, I'm sure you'll be moved on to another story, but if you're not, please give your names to the victim's advocate so that I can contact you, because please, media, do not contact me on this story without a survivor. It's their story. I thank everybody in this case. Sir, I hope somewhere you have heard everybody's words, and it really does resonate with you. Anything else for the record?
Nothing on behalf of the people, I'm sorry.
Nothing but half,
No, Your
Mr.
Honor.
Lasser.
All right. So the media is asked to stay here with all those lovely people who may want to speak with you. Thank you. That's all for the record.
All rise.